Welcome to today's program titled ADA Title III Disability Access Updates, Hot Issues and Litigation Trends. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Min Vu. Min, please go ahead.
Well, good afternoon to those of you who are on the East Coast, and good morning to those of you who are on the West Coast. My name is Min Vu, and I'm a partner here in the DC office of Seyfarth Shaw, and also the leader of the ADA Title III team. I'm here today with my two other partners of the team who are co-leads, Christina Lonnie from our Sacramento office, and John Egan, who is from our New York office, the current hotbed, of course, of much website litigation. Anyway, we are very pleased to be here with you this afternoon to give you an update on what's going on in the ADA Title III legal world, and we have a packed schedule for you. We hope to save some time for questions, so please feel free to go ahead and submit your questions as they come up, and if we have time at the end, we will try to address some of them. So today's agenda, just very briefly, so you know what's coming up. Next slide, please. Okay. So we're just going to give you a little overview of Title III requirements for those of you who don't think about these issues all the time or aren't familiar with them. And then John will go over the national lawsuit numbers and hotspots just to give you a sense for what's going on in the courts. I will cover the Biden administration, DOJ, and what they're up to these days, which is a lot. We're going to give you a quick update on hotel reservations websites and what's going on with those lawsuits, and there were hundreds of them. And then 5 is going to be hot litigation topics. There are a bunch of subtopics here, and we're all going to be jumping in to kind of give you an update there. And then under hot litigation topics would be website accessibility litigation. That is a huge issue right now, so we're going to try to spend a lot of time on that to give you the latest in that area. And then finally, we're going to talk to you about some risk mitigation strategies as it pertains to websites. So with that, I'm going to turn it over to Christina, who is going to give you the overview.
All right, so I'm doing the lay of the land here. Let's dive right in so we can get into the meat. On the next slide, we are talking about what the foundation for our talk is here today. So at its most fundamental, we are talking about the Americans with Disabilities Act, the federal civil rights law that prohibits discrimination against individuals with disabilities. As you all know, it was signed into law by George H.W. Bush, president at the time, in July of 1990. That's significant because when we get to talking about website accessibility, the web was not around at that time. So there's been a whole lot of arguments as to how or whether the existing statutory language and regulatory language should be interpreted in the context of websites. The ADA covers 5 key areas. We're only going to talk about one of those today, but it's important to know the context because we often get asked, well, does this requirement apply to my employees? We are focused on Title III of the ADA today, which does not apply to employment. Title I is the title of the ADA that applies to employment. Title II applies to state and local government activities, and Title III applies to places of public accommodation, which is what our focus will be today. On the next slide, we talk about what the fundamental principles are under Title III of the ADA. So these are the main concepts that y'all need to keep in mind as we are drilling down into the details of litigation and the hot topics that we've been seeing over the past couple of years. So first, the ADA requires that public accommodations have facilities, physical facilities, that are accessible to individuals with disabilities, and they maintain them so that they are accessible. Second, the ADA requires that public accommodations make reasonable modifications to policies, practices, and procedures when necessary to ensure that individuals with disabilities have equal access to the public accommodations, goods, services, facilities, etc. Reasonable modifications. And number three, which will be, like Min said, we're going to talk a lot about website accessibility today because that's such a hot litigation topic. The third concept here under Title III of the ADA is the one where website accessibility really comes in, which is that public accommodations must ensure effective communication with individuals with disabilities by providing them with auxiliary aids and services at no additional charge. And one of the possible auxiliary aids and services that might need to be provided is accessible electronic information technology, as we'll talk about more later. So if a public accommodation violates Title III of the ADA, what are the potential remedies? Well, first, if you are an individual with a disability bringing your own private lawsuit, you can achieve an order potentially from a court that the barrier must be fixed. That's the injunctive relief. You can also recover attorney's fees and costs in achieving that result. If you're under a state law as well, such as the New York State or City Rights Human Rights laws or the California UNRRA Act, you can potentially recover damages or penalties as well. Those are unique to the state laws. Now, if the DOJ brings an enforcement action against you, it can recover penalties in the amount stated here on the slide, just over $97,000 for a first violation and $195,000 for a subsequent violation, in addition to injunctive relief and damages. You might notice that those numbers are different from the numbers in last year's presentation. That's because they are raised every couple years, and actually they were raised effective December 31st of 2021. So those are the potential remedies. Next slide, please. So we throw this slide in just because one of the most disputed, litigated, discussed aspects of Title III of the ADA is whether a business is in fact subject to Title III, because it is or isn't a place of public accommodation falling within the 12 categories that are set out in the law. The 12 categories are stated here. We're not going to go through them right now, but they'll be in the materials. And it's important to note that it is also disputed that even if you fit within one of these 12 categories, if you are potentially a web-only business, in other words, not a physical place of public accommodation, that is one of the hotly debated topics as well, as to whether you are subject to Title III or not. And we'll talk about that more later. So with that overview, very high level, let's move on to see what's going on with litigation numbers.
Great. Thanks, Christina. So we're going to talk about the filing statistics for ADA Title III and website cases. All this information is found on our ADA News and Insights blog. This first graph shows you the total number of Title III filings, all bases, website, physical accessibility, reasonable modification, service animals since 2013. As you can see, for the most part, it has seen explosive growth over the last 8 years or so. Next slide. This shows you same period of time, the three hottest jurisdictions, California, New York, and Florida, in that order. You'll notice that California kind of leads the way. New York flipped with Florida into the 2 spot around 2017 and 2018. That's probably because As Min mentioned earlier, New York is a hotbed for website accessibility litigation. Around that time, 2018 is when they start to really be filed with greater frequency. In 2021, 3 of every 4 Title III cases in New York was a website case. Next slide. Top 10 states focusing, and again, all bases of Title III lawsuits. For 2021, you see California leads the way, New York number 2, Florida number 3. The impact of California is even greater than this, quite frankly, because California sees a lot of state court litigation under accessibility, as well as demand letters. Next slide. This shows you website accessibility cases only. Since 2017, I want to focus you on the increases in 2020 and 2021. So since roughly the onset of the pandemic in early 2020, we've seen a 26% increase in the number of annual website accessibility filings in the country. Really amazing. So as folks were kind of in lockdown, they increasingly filed website cases. Next slide. This shows website cases 2021 on a monthly basis. You notice there's a big jump in November. That's because there's one law firm in New York City that filed about 350 of those 499 cases. Next slide. And this shows you for 2021 the number of website cases. New York leads the way. Again, California is also really prominent in the space based on the fact that there are state court cases that aren't reflected here. State court cases are really hard to track. That's why we couldn't include them on this graph. But you see number 1, 2, and 3 for website cases on this graph. Next slide. Okay, back to Min for the Biden DOJ.
All right, everybody. So whenever there's a regime change at the DOJ, there's also a very different approach to civil rights enforcement. The Justice Department is responsible for enforcing Title III of the ADA, and that's done through the Civil Rights Division within the Justice Department. So Kristen Clark is the new head of the Civil Rights Division. She's the Assistant Attorney General. And you know, there's usually a change within the top leadership, right? There's Kristen Clark, there's her people, and then you have underneath that the Disability Rights Section, which is responsible for enforcing Title III of the ADA. The main, I don't want to overgeneralize, but basically in a Republican administration, usually they try to color within the lines and basically kind of bring bread and butter cases and not necessarily forge new ground or say too much about you not issue too many guidances or really kind of do, you know, just kind of be out there all the time. In a Democratic administration, on the other hand, they tend to be more committed to pushing the boundaries of the ADA and kind of being more aggressive with enforcement. So let's take a look at what's happened in the first year. So we have, first of all, at least, let's see, four statements of interest filed by the Department of Justice in pending litigation brought in private suits. Now, Christina mentioned you have private lawsuits that can enforce the ADA. You can also have the Attorney General, the DOJ, show up and they can bring their own lawsuit as well. Okay, and they would bring either pattern and practice cases or cases of general public importance. Those are the two categories. So the reason these statements of interest are interesting is because there were no statements of interest filed at all during the Trump, the Trump years, right? So you can see a major difference. It's only been a year, and we have statements of interest about the bed heights of the heights of beds in accessible rooms in lodging facilities, self-service kiosks, plasma donation centers, and whether those are public accommodations. And also, the DOJ weighed in on a Texas anti-mask executive order as well. So very busy. I will say that I want to point out a couple things about the kiosk and certainly the bed height statements of interest. What the DOJ said, particularly in the bed height case, is that even if bed height is not specifically regulated, there's not like a rule for bed heights in the ADA standards for accessible design. That doesn't actually end the inquiry. the DOJ basically said, well, there's also that requirement that Christina alluded to about reasonable modifications to policies, practices, and procedures. That's a separate obligation. So if somebody comes in, there's no requirement for bed height, you've got a bed that's too high, you may still have to you probably still have to lower it for the person with a disability who needs it under the reasonable modification to policies, practices, and procedures requirement. So what I'm saying here is keep in mind that just because there's not a rule about it doesn't mean you don't have to do it. Okay, if it's a reasonable modification, consider it and do it if you can. All right. Also, on the website accessibility enforcement front. So during the Trump administration, there was virtually zero activity by the Civil Rights Division about accessible websites. In stark contrast to what was going on during the Obama administration, when basically the Obama administration was going after all sorts of businesses, including H&R Block, for not having an accessible website. So they were super aggressive in the Obama years, pretty much crickets during the Trump years, and then now we're back. So in the first year, you had the Justice Department securing settlement agreements with providers of vaccines, so these folks like, Rite Aid, Hy-Vee, Kroger, CVS, they all provide vaccines at their locations, and they have websites for people to sign up. So that was obviously a very targeted enforcement effort to basically require those businesses to make sure that their vaccine registration websites are accessible. Okay, so they did a whole, it was very busy. They were very busy with that for the first year. I will also say that the DOJ kind of attitude towards enforcement has definitely is kind of back to being very aggressive. There's a lawsuit that's pending in Arizona, for example, against these eye surgery centers, so they're outpatient, and the DOJ is suing them because they are unwilling to basically provide personnel to transfer people who are unable to get onto examination or surgery tables themselves. So these eye centers are requiring the patients to basically pay for a service to get them on the table. And the DOJ is saying that is not okay. You're supposed to be doing that. Interesting question. I think it's an aggressive position to take, but again, they are pushing the envelope. So next slide. One of the things that just came out, within the last month, is a website accessibility guidance document from the DOJ. Now, you will kind of talk about this further, but essentially, both the business community as well as the disability rights community has been clamoring for this kind of guidance. DOJ issued the guidance. We have a blog on it, a blog post on it, and let me just say that it says absolutely nothing new. Nothing that we lawyers didn't already know. I think it was designed to basically tell businesses in a layman, in like non-technical language that yes, your website is covered by the ADA and you need to start making it accessible. That's pretty much like the takeaway from that. And, and raises a few other questions that frankly are not answered under the guidance. So that's all I'm going to say for now, because we're going to talk a lot more about websites later. Next slide. Okay, so now we're going to move on to a slightly different kind of website case. This is about hotel reservations websites. So the ADA has a requirement that hotels have to tell people on their reservations websites the accessibility features of their hotels. Okay, like, is the hotel accessible? What kind of features do they have? That kind of stuff. So next slide. This one law firm in Southern California in 2020, 2021 decided to file like over 550 lawsuits, basically alleging that these California hotels did not provide enough accessibility information on their websites. Long story short, it was kind of a lousy theory because over 80 federal decisions have dismissed cases, basically with this theory. But a handful were allowed to move forward, and we have 4 cases now pending in the Ninth Circuit. So the cases got dismissed, the plaintiffs appealed. And right now, we're still waiting a decision. There were 2 cases argued in February. The rest of the cases are stayed. All right, so now I'm going to turn it back over. Next slide, please, to John.
Hi. Okay. Next slide. All right. So if you attended last year's webinar, our annual webinar, you'll notice that we talked quite a bit about COVID-19. We don't have as much to say about it now, which I'm happy about. Hopefully, this is kind of fading into the background. But we did have the DOJ guidance, common questions about COVID and the ADA, which was updated earlier this year. Talks about how long COVID can qualify as a disability. There's also guidance describing physical accessibility requirements when businesses have outdoor dining, streeteries, when they put dining facilities kind of out there on the street that we see so often in places like New York, as well as online retail areas. I'm sorry, not online retail areas, outdoor retail areas. I'm getting ahead of myself. And so the guidance basically says keep the routes clear, provide an accessible route, even if it traverses over the public sidewalk. And so there's some important guidance there. Also, in this topic of lawsuits over drive-through only service, Swanek and Meiji, both kind of similar cases where restaurants' policies in terms of drive-throughs, fast food restaurants requiring that people use the drive-through after a certain hour in the evening. Individuals with visual disabilities claim that this was a facially neutral policy that had a discriminatory impact, and the defendants prevailed. And they prevailed basically, it's kind of similar reasoning, that there was no greater disparate impact to people with disabilities than to those without disabilities that don't have access to cars, right? So folks without disabilities that don't have a car would have to go to the store or the restaurant the same way as people with disabilities, i.e. as a passenger, okay? Next slide, please. Probably the most noticeable category of COVID-related Title III lawsuits that we saw involved face masks, individuals with purported disabilities who claimed that they couldn't tolerate a face mask and then brought a claim alleging that a business discriminated against them based on a face mask requirement. Face masks are in the news in the last day or so. They're coming off, but they may be going back on, so I want to quickly touch on it. Only like less than 100 cases nationally on this, nothing like website accessibility with the plaintiff's bar kind of rallied around. Many of them are pro se, and candidly, they're probably not teed up correctly, but the legal issues really concern whether there are eligibility criteria, i.e. wear a mask, that are supported by a legitimate safety requirement, and whether businesses properly discharge their obligations to provide reasonable modifications of policies, practices, and procedures to deal with, on an individual basis, people who say, hey, I need to come in, but I can't wear a mask. What do you do? Just a handful of plaintiffs' firms have filed claims. Most have been dismissed. Ones that have survived have really involved really kind of really legitimate folks with disabilities who've said like you know, there was a straight up rejection. There was no way that I could get access to the goods and services. And those have kind of survived motion practice. That's it for COVID. Yay.
Awesome.
Right.
So that will take us from COVID to another issue that it was not as cutting edge as COVID, but continues to be cutting edge. So just to level set real quick, I'm going to be your forest person again, and then Min and John are going to really get you into the weeds on what we're seeing with web and mobile app litigation and the case law that's coming out. But big picture, the reason why we are focusing on websites, mobile apps, and kiosks here is not because there are no longer any other lawsuits filed on any basis under the ADA. Remember the stats that John gave you in the beginning. We saw 11,000 lawsuits filed alleging violations of Title III of the ADA in federal courts last year. That was a 4% increase over 2020. We saw almost 3,000 of those lawsuits, though, be filed purely on the topic of the accessibility of websites and mobile apps. And that was a 14% increase over 2020. So not only is the website phenomenon still very alive and well, it grew during COVID because of the move to online life, even more so than ever. And it has this uncertainty, as you'll see as we dig into the case law, that we don't have in many of the other areas of Title III of the ADA. because we have regulations stating, you know, how your physical facility needs to be built down to the half-inch sometimes. We don't have that under the website accessibility regime. So going on to the next slide, there are some statutes and regulations that do expressly require websites to be accessible according to a specific standard. Title III is not one of them. Neither is Title II. So we have on this slide the various laws that may require accessible technologies. Title II and Title III, the way the litigation has gone and the way the DOJ has stated its position is that even though there is not a regulation stating how a website must be coded to be considered accessible in compliance with Title III or Title II, the general non-discrimination principle, the effective communication obligation, essentially websites need to be accessible to be considered in compliance with Title III. The DOJ has said that. We have some cases that say that. The Supreme Court has not said that yet, but that is the way the case law has been going, despite any express statement in the statute of regulation to that effect. In contrast, under the Rehabilitation Act, we have Section 508, which essentially incorporates the WCAG, the Web Content Accessibility Guidelines, as the standard for federal agencies to essentially meet for accessibility. We have some other laws like the Air Carrier Access Act, the Medicare regulations, Section 1557, which have incorporated specific web accessibility standards as well, usually WCAG 2.0 AA. We have some international laws that we're asked about sometimes, like in Ontario, that also have a specific standard. Title III does not, just remember that. And then also don't forget about state non-discrimination laws as well. There are some usually applying to state agencies that may require conformance to a specific standard. On the next slide, this is just our standard slide. That's a refresher really for folks who are new to web accessibility. Here we're giving examples of what it means for a website to be accessible anyway. Essentially, it means that the website is coded so that it can be used by people with various types of disabilities. If the website isn't coded properly, then a screen reader cannot interact with it. People who are blind use a screen reader to essentially read out to them what is shown on the page. And you need to have things like a description of a picture coded behind the picture. That's called alternative text for the screen reader to read off the picture. You need to have keyboard only capability to navigate through the site for a person who cannot see what is on the page or may have limited mobility and use of the mouse to be able to use the website. Color contrast, text resizing for people who have low vision or color blindness. Color cannot be the sole method of conveying information. No flashing content for people who have epilepsy and for people who are deaf or hard of hearing. Captioning for our audio content. The vast majority of the lawsuits that we see are brought by people who are blind, so that's typically the focus. But don't forget that there are a diverse number and a diverse types of disabilities that are affected by websites that are not accessible and that need to be considered, and then in fact are considered in the WCAG guidelines. Next slide. So I keep talking about the WCAG guidelines. There's this running joke about how you really pronounce them, WCAG, depending on what region you're from. You can also refer to them as the WCAG, the Web Content Accessibility Guidelines. They are not a law, they are not a regulation. They are a set of guidelines that were created and published by a private group of experts in the field of web accessibility called the World Wide Web Consortium. They've been around a long time, despite people saying this whole website accessibility thing is brand new. We are on version 2.1 of the WCAG guidelines. 1.0 came about 10 years before 2.0, which came a couple years before 2.1 as well. 2.0 is still considered, really the prevailing standard, and that's in part because it's in the many consent decrees that the Obama DOJ had entered into regarding web accessibility. It's in most, the few court decisions actually that mention a standard, and it's in some private advocacy agreements. There are private party advocacy agreements that have been made public on advocates' websites as well. But 2.1 is out. A lot of companies are moving that way. A lot of advocates are moving that way. It doesn't differ that much from 2.0. However, it just adds 17 additional criteria onto 2.0. We're also often asked, well, if I meet A, is that okay? Many of the criteria are either tagged as a level A, AA, or AAA. You really need to be meeting A and AA for your website to be considered accessible. A alone would not be sufficient. AAA criteria are very use specific. The last bullet here, important to note, it is not a legal standard, as I noted, under Title III. It is not adopted into any regulation, but we kind of refer to it as the de facto standard, because if you're going to put an expert on the stand, every expert in the field is going to agree that this is essentially the standard that they would look to as the measure of accessibility of a website, in addition to, of course, not is it just technically coded to the WCAG guidelines, but is it usable as well? Next slide, please. And I mentioned website regulations, website accessibility regulations, that there are none. Here is your super high level overview. Obama DOJ put out an advance notice of proposed rulemaking. It was out there. They put out a supplemental advance notice of proposed rulemaking, asked over 100 more questions for comment. Then the Trump DOJ came in and said, we don't like regulations. We're pulling that back. So that was the end of any regulatory effort to get a regulation that actually might set a standard for web accessibility under Title III and Title II. And then just this year, 181, I think, if I remember the number right, advocacy groups joined a letter asking the DOJ to issue regulations on website accessibility by the end of the Biden administration. Shortly after that, we got the web accessibility guidance that Min referred to earlier, which, you know, who knows, maybe is the DOJ saying, we're not going to issue regulations, so here's some guidance instead. Next slide, please. So with that, let's dig into the weeds. Oh, and I'm digging in the weeds. I'm sorry, I forgot. I'm going to set the stage for digging into the weeds, though. Here's the high-level overview about what Min and John are going to talk about. So the key themes that have come out of the case law. Number one, that federal courts disagree on whether web-only businesses are covered public accommodations. Remember that slide I had up in the beginning about the 12 categories of places of public accommodation? That's where this argument comes up. Can a web-only business be considered subject to the ADA, or does it have to have a nexus to a physical place? There's some, differences among state courts there as well. Point number two. If you entered into a settlement agreement saying we're going to agree to make our website accessible and I get sued again, can't I use that to say, come on, I've already agreed to make the website accessible, so there's no injunctive relief that can be had against me? Most courts there are saying, no, that those are between two different private parties, but we'll talk a little bit more about the case law there. Number three, being in the process of making your website accessible usually does not moot the case. In other words, it does not mean that there's no case or controversy anymore before the court if your website is not yet accessible, but it's on the way to becoming accessible. But if you have made the website accessible, then in theory, there's no injunctive relief to be had, case is moot. Number four, if the plaintiff cannot ever use the services of the business whose website is inaccessible, then the case may be dismissed for lack of standing. They can't possibly have been injured if they could never use the services anyway. And the, overall point here, part of the reason we're still in this very wild west of web accessibility, despite the fact there are no regulations, is because there's only a handful of cases that have been litigated to judgment. So we still have just this hodgepodge of trial court decisions, and then, the vast majority end up settling rather than being litigated. Next slide, please. Okay, so I'm gonna blow through these cases because they're not new news, but they are some of the only dispositive decisions we have on them. So we can't, we'd be remiss if we didn't at least mention them. So the first big one, we have very few circuit court, federal appellate court decisions on the issue of website accessibility. We have no Supreme Court decisions, as I mentioned earlier. So here's one of the few. The Robles versus Domino's Pizza case got a lot of publicity for that very reason. It's one of the few federal appellate court decisions we have on the topic. The main takeaways from the Domino's cases, or case, which, is actually still going on. But what the Ninth Circuit said that's notable is, first of all, that, due process, that you can't require a business to have an accessible website because there aren't regulations, isn't going to fly. The court said we issue decisions all the time on things that aren't expressly set forth in the regulations. That's what we do as courts. So we're not going to buy that argument. The Ninth Circuit also said that the ADA applies to websites and mobile apps that have a nexus to a physical place of business. And then I'll talk about the dispute again amongst courts on that topic later. And number 3 was telephone service as an alternative could not be decided on a motion to dismiss because that's an inherently fact-specific inquiry as to whether the telephone service gives equivalent alternative effective communication. Case is still going on, even though partial summary judgment was granted on remand to the plaintiff because the court found that the website was not fully accessible to the plaintiff because a future order can't be placed using a screen reader. Next slide. Gill versus Winn-Dixie was the other case on the other side of the country in Florida, also appellate court case, federal court case that got big news and then ended up being a whole lot of ado about nothing because, sparing you the up and down drama of the saga, eventually, just a couple months ago, in response to a petition for rehearing, the 11th Circuit vacates both the appeal of the case and the judgment in favor of the plaintiff from way back in 2016, 2017 as moot because the injunction had expired pending the appeal. So the case essentially stands for nothing now, but the couple of key points that are worth making along the way that the courts had held, which are no longer good law, are that this was one of the very first cases where the court actually ordered a defendant to make a website accessible by a certain time and according to a certain standard. WCAG 2.0 AA required training, required third-party content to be accessible. That was a big deal as well. Gomez versus GNC was another case that made an award on the merits. Again, it was stayed pending Winn-Dixie, so nothing else has happened since Winn-Dixie is done. Next slide. Some California decisions because, statutory damages here in California, we see a lot of litigation. So this case, again, not new news, but another case, a California case, which ordered the website to conform to the WCAG 2.0 AA criteria to be accessible. Also said websites with a physical nexus are subject to Title III of the ADA, an state appellate court decision, which is why it is significant, and the third-party content point as well, and effective communication via telephone point as well were both addressed in this case. Next slide. And Thurston, busy plaintiff, gets around versus Omni. In the Thurston versus Omni case, this is the new one from 2021. Here, the jury found that there was no intentional discrimination. So it resulted in a verdict for the hotel, which is a big deal. That if you don't have an underlying violation of the ADA, under alone, you need intent. The Davis versus BMI B&D Travelware case was another California state court case where summary judgment was granted for the retailer, against the retailer, and the court found that an inaccessible website discriminates against a blind customer in violation of the Unruh Act. Next slide. And this final case, we just throw it up here because I think it's fascinating. This one was issued on a default judgment. It was out of the Southern District of Indiana, but it's significant for, number one, the case followed 7th Circuit dicta in finding that Title III applies to websites without a nexus to a physical space, in other words, web only. And the court ordered the defendant to bring the website into compliance with the ADA and implementing regulations within 90 days or would order the website shut down. But the court denied the plaintiff's request that the defendant be required to hire a certain consultant, adopt policies, procedures, etc., as a measure of compliance. Next slide. Okay, our website's covered by the ADA.
Okay, so I'm going to jump in to take this topic. So the question of whether websites are covered by the ADA is still unresolved. Basically, when you go back to the kind of definition of what is a public accommodation, remember that slide where we kind of had the 12 categories of businesses? One of the fundamental questions which the circuits disagree about is whether a place of public accommodation actually has to be a place, okay, a physical place. And I'm going to go through kind of the various circuits that have opined on this shortly, but essentially the courts are divided on this issue. So in the 11th Circuit, for example, the 11th Circuit says no, a website is not covered, is not a place of public accommodation under the ADA because it's not a place, right? So they're sticking with it's got to be a place. Having said that, though, there is still a way that the website could be covered under the ADA because essentially it's a kind of a benefit or service offered by a place of physical accommodation, assuming it's not a web-only business. So in other words, let me just be clear. If you're in the 11th Circuit and you're a web-only business, you're dead in the water as a plaintiff, all right? You're losing that one. But if the business has a physical location where customers, get goods and services, then the strategy would be to demonstrate that the barriers on the website are preventing the plaintiff from enjoying the goods and services at the physical place of business. Okay, if that makes sense. So it has to be like the stuff on the website has to be a barrier to access at a physical place. So that's the 11th Circuit standard. The 9th Circuit has a similar, also believes that a public accommodation has to be a physical place, but the standard is not quite as high as the 11th Circuit. So in the 9th Circuit, if you can show that a website has a nexus to a physical place of public accommodation, then that website would likely be covered by the ADA and the non-discrimination requirements of the ADA. So, for example, in Robles v. Domino's, the court didn't have to decide. Well, Ninth Circuit had already decided that a public accommodation has to be a place, and there was clearly a nexus because the website allowed people to order their pizza and pick the pizza up at a physical place. So clearly there was coverage there. In contrast, in the Earl versus eBay and Cullen versus Netflix cases, those were businesses that have no physical place at all, and the 9th Circuit just said not covered. Okay, so again, online-only businesses are not covered in the 9th Circuit and the 11th Circuit. Next slide. Now, in the 3rd Circuit, has not actually had a chance to answer this question in the context of a website case. However, it has held in other types of cases not involving websites that a public accommodation under the ADA has to be a physical place. And following that precedent, the Eastern District of Pennsylvania, for example, recently granted a motion to dismiss a case that was brought against a web-only business. Okay, so they're lining up mostly with, the 11th and 9th Circuit. Now, the 1st Circuit, kind of like the 3rd Circuit, has not addressed a website case yet, but it has held that a public accommodation does not have to be a physical place. In this case called Car Parts versus Automotive Wholesalers Association of New England, Inc. Wow, that was a long name. Anyway, so in Car Parts, Car Parts was about an insurance policy that allegedly discriminated against people with disabilities. Okay, and that was sold by that was obtained through an employer. So the 1st Circuit was like, you know what? It does not have to be a physical place, so there's coverage for that. Now, so the lower courts, district courts, following the 1st Circuit precedent in Car Parts, have definitely held that web-only businesses are covered, such as Netflix, right? So Netflix won in the 9th Circuit, lost in the 1st Circuit, or in the district court level. Okay, next slide. Now, New York is a really interesting one because there is a raging conflict among all the various judges there. All right, that's the only way I can describe it. So the 2nd Circuit, there's this decision called Pelosi versus Allstate, And it involved an insurance policy, again, that allegedly discriminated against, the plaintiff with a disability, but it was purchased at a physical location, like an insurance office. Okay, so honestly, like, there was some verbiage in there that suggested that maybe the Second Circuit thought that, it doesn't matter if the discrimination happened someplace else, out, not at the place, it's still covered. I don't think it's actually relevant, particularly to any of these website decisions, but the district courts, all the judges in the Southern District of New York, however, have kind of read Pelosi to mean that web-only businesses are covered under the ADA. Okay, that there's no physical place requirement under the ADA to be a public accommodation. The Eastern District of New York, however, those judges, at least the ones that have opined on this, don't seem to agree. So we've got the Weingart versus Newsday case, the Suris versus Gannett case, where basically those judges said, no, not covered because they're not places of public accommodation. Now, I will tell you this, there's a new decision, just came out like a couple days ago from the Western District of New York that sides with the Southern District of New York decisions, right? So in that case, this is actually kind of a disturbing case because the lawsuit is against a kind of a video game service, like you subscribe and then you get to play all these video games. But the thing is, the service doesn't actually make the video games, right? So the plaintiff was alleging that the service, the video game service, violated the ADA by not having closed captioning or captioning so that he could interact with people on this platform. But actually, the allegation goes to the actual content of the subscription service, meaning the games themselves, as opposed to like getting into the game, before you get into the game, being able to communicate. So the judge basically said, on a motion to dismiss, this service is covered, kind of like Netflix. In fact, he talked about Netflix, and I'm not going to get into, I'm not going to get into like the content issue, like that they don't make the content, so they can't be captioning it. Too early. I'm not getting into that right now. So this is kind of this is a disturbing one, I think, for businesses, and we're going to watch it and see what happens. All right. So that's the situation in New York. And by the way, this is why New York is so popular as a venue for all these website cases, right? Because you have very sympathetic judges, especially in the Southern District of New York. In the last quarter of 2021, 89% of web access cases filed in New York were filed in the Southern District. And there was a decrease in the Eastern District of New York in quarters 3 and 4, obviously because they're not quite as sympathetic. It's harder. All right, next slide. I also want to talk about California because even though, remember on our numbers slide, the California lawsuit situation in federal court for website accessibility cases seems super low compared to New York, right? Well, that's because they're all going to state court and we don't track those numbers. There are tons of these website accessibility lawsuits brought there, and the outcomes are just all over the place and slightly crazy, honestly. So which means it's a total crapshoot if you're in California state court. So for example, in this Martinez versus Kidia case, this state court judge said, you know what? We don't care if the Ninth Circuit thinks that a place of public accommodation is a place. We're ignoring that because we don't have to follow it. There's a conflict in the circuits. The ADA covers a web-only business, according to this judge. And then we actually have other judges. We didn't mention these cases on our slides, but there are other judges that actually go with the Ninth Circuit view. So depending on the judge, if you're web only, you can have a very different outcome. The other kind of somewhat disturbing case coming out of California is Martinez versus Diamond Hill Vineyards. So there, okay, just to get into this, under the Unruh Act, which is kind of the ADA, kind of version of the California version of the ADA, but different in many respects. Under that law, you either win by establishing that there's been an ADA violation, or you also win by showing intentional discrimination. Okay, so nobody has ever really normally gone under the intentional discrimination theory, because really, I mean, having an accessible website, have you really intentionally discriminated against disabled people? Most of us would say no. But this judge actually said that having an inaccessible website may be considered intentional discrimination under the Unruh Act. Wow. Okay. So one judge, obviously we'll see how that goes. And actually, sorry, it's not one judge. It is a Court of Appeals of California. So this is actually much more significant, because now the other trial judges have to follow that unless there is another opinion from a California appellate, court. All right. I think I've covered this topic. Let's see. Who's next?
Yep, it did.
Sorry.
Right, no worries. Okay, so we got 10 minutes left. You all are asking great questions. We want to get to them. So we're still in the weeds, but we're going to move through a little quicker now and kind of hit the highlights. Mootness, right? ADA Title III claims seek injunctive relief. Court to order something. To do that, you have to show a likelihood of future harm. If there is no such future harm, then there's no subject matter jurisdiction. So if you've mooted a claim, if you've eliminated the violation, then arguably you can get a case dismissed on that basis. And these are cases where these mootness arguments were successful. Diaz v. Kroger, New York case, there basically the defendant put in a declaration that I fixed it. It's compliant. It's conformant with WCAG. Plaintiff's counsel did not put in an opposition with a client declaration. So a little weird. I don't think you can expect that now, but the court ruled that mootness had been established. The Langer cases, Be Our Guest and Russell Motorsports, both involve captioning. They're kind of like success stories, I think. You can fix stuff and get cases dismissed based on the representation that and the evidence that the videos were captioned for the benefit of the deaf or hard of hearing, or they were removed. The court basically granted dismissal based on mootness as to the federal claim. There are kind of nuances with captioning, whether it's the accuracy of transcription or sound effects, but I think it's generally easier to caption stuff than it is to make stuff compatible with the screen reader. Okay, so good news on captioning in those two cases. Rizzi versus Hilton Minvu's case, my partner, that's an example of how to do a mootness argument in federal court in the Eastern District. The importance of an expert submitting a declaration that you can get to where you want to go, you can learn about the hotel, you can execute a reservation, you do all that stuff, successful outcome there. Next slide. On the other side, these are cases where mootness was not successful. The first and the last, US Wings and Yield Street, both involved widgets, accessibility widgets. Yield Street was the userway widget. Defendant in US Wings used the accessibility widget. Both were not successful when the lawyers attempted to make mootness arguments. So if you're looking at an accessibility widget that's charging you $1,000 and claiming that you're going to be WCAG conformant, sounds too good to be true. And for these defendants, it was. Walters v. Skinny Ties. There you had battle of the experts. You had conflicting testimony regarding 6 to 7 alleged barriers to people with visual disabilities on the site. There was a question of fact, survived the motion to dismiss. Haynes v. Hooters, we talked about that earlier. Settlement agreement entered into by Hooters to make their site WCAG conforming. Was it enough to moot a claim? No, it was not. The second claim that was filed was broader than the terms of the settlement agreement in the prior case. And also, as Christina pointed out, the defendant was in the process of making the website accessible. Therefore, the violation was not rendered moot. Next slide, please. Okay, so this is kind of an important slide. We see a lot of plaintiffs' lawyers coming over from like FCRA, Fair Credit Reporting Act, to Title III. And so too do we see this watershed decision come down recently by the Supreme Court in TransUnion v. Ramirez on the topic of standing, whether there is a concrete injury sufficient to address an issue in federal court. We see these cases here kind of grappling with it, but coming out in completely the opposite way. So Hardy versus West Point Realty, Second Circuit decision interpreting this TransUnion case to hold that the allegations that a hotel reservation site did not have the necessary information was not sufficient for standing. Just to back up for a second, this TransUnion case, well, you know, I don't want to get into the TransUnion case too much, but the point is that Judge Sullivan in West Point Realty basically held that in order to establish standing, an ADA reservation plaintiff has to show downstream consequences from failing to receive the required information, an interest in using the information beyond bringing the lawsuit. In the case, the plaintiff had no intention of visiting the area where the hotel was located, no intention of making a reservation. It was a pure tester, and tester standing was not enough. It does not obviate the need for Article 3 standing, concreteness, injury in fact. In Laufer v. Arpan, the 11th Circuit, also kind of grappling with TransUnion, comes out a different way, the opposite way, holds that a plaintiff that also didn't intend to go to the hotel or the region had standing because of the humiliation, embarrassment, and frustration resulting in not getting the information necessary or called for under the regulation as it regards to the information about accessible features, accessible rooms, and the like on the hotel website. Next slide, please. Okay, these are mootness and standing cases in the hotel context. You kind of have them there, but I want to keep it moving to the next slide. Credit union cases, kind of unique set of facts where the plaintiff had no chance essentially at using the services because he was not eligible for the credit union. Court held that there was a lack of standing because there's no concrete likelihood of future harm. Next. Back to you, man.
Yeah, so before we, well, at the end of the, well, let me give you the CLE codes at this point. So everyone pick up your pens if you need CLE or HRCI credit. The CLE code is S is in Sam, S is in Sam, S is in Sam. Sorry, no, start over. S is in Sam, S is in Sam, Shaw, S-H-A-W, 3527. So again, it's SS Shaw 3527. The HRC program ID is 592540. Again, 592540. Okay, we have very little time, but I'm just going to say this. If you have a self-service kiosk in your business, it either had better be accessible, or you need to have employees providing prompt and effective assistance, okay? That was the difference between this one case involving a healthcare check-in kiosk at a diagnostic lab and the Walmart case where there's like a self-service point of sale device. There, in the Walmart case, it was proven that the employees were like super diligent about like providing assistance to people who were not sighted. And in contrast with the diagnostic lab case, the assistance basically really, like people really had to wait for the assistance and it was just not timely. The DOJ weighed in on this, and this is one of those instances where, you know, we're showing that the Biden administration is much more aggressive about these issues. And believe it or not, this case has been very busy and is going to trial in November of 2022. So we'll be watching that one. Okay, next slide. Okay, so very briefly, I'm just going to talk about risk mitigation strategies. So this is mainly about websites. So obviously, you should be creating and maintaining web accessible mobile apps and websites. What I tell people here is when when you get a review of your website, you're going to have like 3,000 errors or something. So you're going to have to prioritize. So make sure to prioritize the user journeys that people normally would use on your website. In other words, clear the make those highways accessible before you make the secondary roads accessible. You see what I mean? And then, save the roads that nobody uses for later. That's how I kind of like to analogize to, on this issue. It's good to have an accessibility statement on your website under a footer called accessibility, but please don't just, pick like a generic accessibility statement. It kind of needs to be tailored to your situation, okay? And also I would usually try as a good practice to put a telephone number on the accessibility statement. So if people want to report problems, they can reach you or get help. Or basically get help so they can do what they can't do on the website in a timely fashion. Vendor contracts, if you're actually going to hire somebody to make you a website, please, let's include the WCAG 2.0 or 2.1 AA in that contract. They're going to resist you and fight you, but you should fight hard for that. Third-party content, there's all sorts of stuff that, content you might lease or, you might license to put on your website. Just be aware that, in that Winn-Dixie case, the judge thought that third-party content needs to be accessible. So you need to be aware and really vet for that. And then finally, I mentioned the telephone line. If you think your website is not accessible, it's usually good to be able to provide help accessing your goods and services in some other fashion that works for, say, people who are blind. 24/7 telephone line is one such option, but it better be good and people would better be answering the phone when people call. All right, well, that concludes the webinar, and we are at 3 p.m. So I don't know, panelists, do we want to answer a few questions just for the people who want to stay on?
I think we can just, folks want to reach out to us after, they can feel free. I tried to answer a couple of questions just directly via email.
Right.
We'll let everyone have their day back, and any burning questions, feel free to reach out to any of us directly.
All right, well, thank you for attending.
Thank you to our presenters, and this concludes today's webinar. Thank you all for attending.